common question that I receive from my clients during the initial stages of a separation is how to best protect your assets while you're negotiating any terms of settlement with your ex-partner. One of the important assets to think about is your home, and in particularly how you might own that property on your title deeds. There's two ways that you can own a property. One is as a joint tenant, and the second is as tenants in common. The main difference between these is that as a joint tenant, you collectively own your property with your ex-partner. There's no individual share recognised, and if either of you pass away unexpectedly, the remaining person will inherit that property in its entirety. This prevents you from being able to leave any share of that property to anyone in your family, and it's important to be thinking about this in the early stages of your separation. The second way that you can own your property is as tenants in common, which means that you have a recognised share in your property. It could be a 50-50 split, an 80-20, but really the main importance is that there is an individual recognised share of your ownership in that property. Whilst you may not look to do anything about the ownership of your property, it's important to know that if you have a joint tenancy arrangement, you can sever that tenancy, which means that you change to a tenant in common and have a recognised share in the property. You may consider this if you have health concerns, if it's important to you that you preliminarily divide your assets while you're negotiating a complex separation, or you may do it so that you have peace of mind that there is a recognised share of your ownership in that property.